5 minutes past 10, our talkback lawyer David Whiting is here to help you with free legal advice. 1300 222 774 is the number to call. 1300 222 774 if you'd like some free legal advice from David Whiting. And David, good morning to you.
Good morning, John.
The legal community rocked by the death of another magistrate late last week. Steve Mile on Thursday. The courts were notified that he'd sadly suddenly died, and literally the magistrates' court just in Melbourne just about shut down, as it did in many regional centres as well, and people absolutely shocked at the news. And that's the second sudden death of a magistrate in recent times here in Melbourne, and serious questions now circulating about the stresses of the job.
Yeah, pressure of work.
Yes, amongst other things.
Yeah, the time allowed is in fact very limited. There's in a sense, the throughput in the magistrates' court is just extraordinary.
Yep, and the unrelenting nature of it. I mean, I can't imagine. I've got friends who do this job, and hearing family violence cases one after another all day,
yes,
day after day,
yep,
week after week. What effect does that have on you? I don't know.
Well, they certainly talk about that kind of effect when you're looking at prosecutors doing sex offences.
Yes. And judges too. I mean, there should be a rotation through, so you're not always doing the same thing, shouldn't there?
There ought to be, yes. You can't spend your whole life doing CityLink fines. So, there needs to be a rotation, and that's why you might do a country stint, or where you just don't get that kind of... you don't need to deal with exactly the same kind of offence all the time.
Yes,
and some of them are more stressful than others. But look, they sit right through. I think magistrates work very, very hard.
Oh, there's no doubt they do. You only have to go and watch to see. And this is going to upset a lot of people, but I'm going to say it anyway. The practice of appointing younger and younger people to the bench. It's great when it means you get a fresh perspective and you get a younger and more contemporary outlook. But if you appoint someone who's 55, they're going to do the job for a fixed period of time and then retire. But if you appoint someone who's 35 or 40, they're doing it for a hell of a long time.
Yes.
And that has an effect on how they do it.
Yeah, and I suppose the theory, at least, John, is that if you've got 40 years of life experiences or 50 years of life experiences before you take the job, you may be better at it. I don't know. I think it depends on the individual, but it's a very long time to be doing the one job.
And the determination to appoint more and more women meant that you were looking at younger and younger candidates.
Yes.
Which means you were looking at people with less experience, and they were going to be doing it for a really long period of time, and that's having an effect too. So anyway, these things need to be worked through. There's some fantastic litigation underway at the moment in the federal court here between the establishment of the Liberal Party and the establishment of the Liberal Party fighting with each other over a $70 million trust fund that's supposed to be used for Liberal Party political purposes. Michael Kroger, the president of the Victorian branch.
I don't think it says Liberal. I think it says conservative policies.
So
and
Michael Kroger's saying
it's 3XY.
3XY, yes, the sale of the radio station. Kroger wants his hands on the money, and he's suing Hugh Morgan and John Calvert-Jones, the grandees of the Liberal Party, who are the trustees, over exactly what it should be used for. Alan Myers, QC, at whatever is the appropriate rate these days, has gone into...
Truly amazing, I think, is his hourly rate, or his daily rate, yes.
And he's yesterday, you could have sold tickets for this, cross-examining Michael Kroger. I would have thought that would be the hottest ticket in town.
It probably would have been, yes.
Financial Review's got a fair bit of transcript.
Oh, okay. Then I shall read it this morning then, John.
I recommend it. I recommend it. Other things?
A couple, John. I had, on a really light note, a Romanian court has has confirmed the declaration of a person's death when he was in fact present in the court before him.
Say again.
This gentleman was Romanian. He went off to live in Turkey. His wife applied after a number of years for him to be declared dead. The court declared him dead. He was then expelled from Turkey because his papers had expired, and he goes back to Romania, and the Romanian government says, no, you're dead. So, as he says, he's in a position he can't hire a lawyer because he's not alive. So, yes, at least I would like to think the English courts or our courts would come along and say, we're now correcting the decision. But that's the way it is.
You know what else is happening in Romania? They've just redefined corruption.
In a positive way, John?
No, they've redefined it so that the government's mates who were found guilty of various offences under the corruption laws, retrospectively, they've changed the definition of corruption so as to get their mates off.
Okay.
It's not bad, is it?
That's a democracy for you, John.
That's fantastic. That's Romanian style.
Yeah.
From the people who bought you vampires and Frankenstein and the rest of it.
Yes, Count Dracula. Well, you will see Google Home and Amazon Alexa, and there's an Apple product as well, all of which listen to you 24/7. Mm-hmm. And if you say the key words, they will do whatever it is that you ask. Play some nice music, tell you what the weather is in Cape Town, something like that. There have been a couple of cases decided in the US that have relied upon the audio tapes. So in order to be listening all the time, John, you actually they presumably record it in some form. So there has been a court case in the UK where there was an acquittal on the basis of material that was downloaded from one of these sites. So sorry, you buy one of these gadgets as a home assistant, so you can, for instance, say to it, what's the forecast for Sunday? And it'll tell you. Yes. You can just shout that out in the living room, and this little thing will, like your phone, like Siri on your phone, it'll start to tell you, or if you're saying, what was the name of that film with Matt Damon in it, and it'll yell it out. Yes. But it's also constantly on, John.
It's storing information.
Yes. So the suggestion is that you might be able to subpoena some of that evidence in a trial. There's been a couple in the States where it's happened. Banking Royal Commission has been fascinating from my point of view to see the different approaches of and the problem is if you've got an organisation like that, you have to work out where your position is between profit and social service. Mm-hmm. And I think the suggestion at the moment is there's too much on the profit and not enough on the social service.
Okay, the tweets coming out from the Royal Commission and the reporters who are covering it are fascinating. Even today,
are they allowed to tweet from inside the court?
ANZ admits it will still use customers' declared expenses even if bank statements showed actual expenses were higher. So they just make up when they look at your they look up your statement of affairs, where you go to borrow some money from the bank and you have to say, I spend this much on rent and I spend this much on petrol and I spend this much on credit cards, and you can pretty much put anything down and they won't query it, check it, verify it, challenge it. They'll just go, that'll get your approval, and off it goes.
Well, that's where I remember somebody telling me, well, if you want a higher percentage, I'll just value harder. Yep. I'll value lower. Yep. And I had some homework from last week, John. I had a gentleman from last week who had he was on light duties. Supposed to be on light duties and wasn't getting his work cover, light duties. And I suppose his real question is, well, what happens if they don't give me light duties? Well, light duties can in fact be the same duties for shorter time. If they don't give you light duties, then what you simply do is you go back to your doctor and you explain to the doctor what it is that you're doing, and then you get a certificate that says you're not fit enough to do those duties. So effectively it's it's the tussle between what the employer says is light duties and what your doctor does. And then you go back to the insurance company who's handling the claim, make the issue and let them deal with the employer.
Okay. Oh. All right. I hope that was of some help. Let's get to today's callers in Warburton. Tanya, good morning to you. You're through to David.
Good morning, David and John. I had an incident on the weekend where a truck went up my road and got caught on the top of the power line and ripped out the mains box from where the power line is attached to my house.
Yes.
And AusNet telling me that I need to pay for it because it was damaged on my house. The truck drove off.
Yes.
So nobody knows who the truck driver is.
Yes.
I have no idea what to do. AusNet are being very unhelpful.
Was it a line over the road or was it a line in your driveway?
No, it was a line over the road.
And who put the line in?
AusNet would have put it in.
And They will have an obligation to put the line at a particular height.
Right.
They have no control over the size of the truck that drives down your lane.
Yeah.
I would be talking to the Essential Services Ombudsman and see whose responsibility it is.
Okay, because I think the line was too low, because it was lower than my phone line, and I've tried to measure my phone line from the road and it's about 3.8. But AusNet have been very unhelpful, telling me that all kinds of different measurements depending on whether it's in the middle of the road, and because the line was ripped down, I've got no idea how tall it was. No. All I know is now it's taller than my phone line because they've put it back up.
Okay.
And it was underneath the phone line previously.
Can I suggest that Essential Services Ombudsman is the person that I would talk to?
All right.
And have the complaint.
In breaking news from the courts, people may well be familiar with the fact previously published that Geoffrey Rush, one of Australia's most famous actors, has been suing the Daily Telegraph for defamation over a story alleging that Geoffrey Rush may have done something wrong whilst acting in a play on stage in Sydney. He has sued the Daily Telegraph for defamation. The Daily Telegraph wanted to publish in their court documents a whole lot of other stuff about Geoffrey Rush. Geoffrey Rush's lawyers said to the court that would be scandalous and they shouldn't be allowed to do it. In a tweet that I've just seen, in a crushing blow to the Daily Telegraph, their defence against reporting of inappropriate behaviour against Geoffrey Rush, the federal court have ruled that allegations that their attempt to publish a defence on the basis that the allegations might be true is too vague. They're not allowed to publish material in their defence that's outside what's in dispute, and they're ordered to pay Geoffrey Rush's costs
of
about
that
the
application.
Argument. That's a big win, procedural win for Geoffrey Rush, because the argument was that the Daily Telly were trying to get in through the back door of the court proceedings, what they never could have published
without
on the front page of the paper.
And of course, the privilege attaches to what you publish in court proceedings.
Yes, so they were saying you can't do through court what you'd never be allowed to put on the front page of the paper, and you can't do that as part of defending a case for defamation.
Which is reasonable.
Yeah, more than reasonable, I personally would have thought. So,
John, before we take to the next caller, can I say thanks to the ABC, I was in Warrnambool for the weekend, and I was at the Koroit Hotel listening to an Irish band, and one of the guitar players said, if anybody hears from Camperdown, I should let you know that the Camperdown Golf Club is about to go with the fires. And the feeds on ABC Rural Radio, out of Ballarat and Warrnambool, were just fantastic. So Saturday morning, and you look at the map and you see there's red to the left of Warrnambool and red to the right of Warrnambool. The updates were just amazing.
And the app, did you use the emergency app as well?
I used the emergency app, and that was the bit that terrified me because it showed me the colour, the bits that were red, and there's this road going out through Mortlake and great amounts of red to the left and the right.
Yeah.
And you just think, what time should I leave?
We called in all the people in regional radio who were working right through the weekend, but ABC Radio-Melbourne did not go to round-the-clock alerts, although we were on standby, and I know Raph Epstein and I were both on standby and in constant touch with our emergency coordinator, and we were ready to come in if we were needed, but it was deemed that regional radio was doing the job and Melbourne didn't need to get involved. But I'm glad that it worked for you.
I did. I tried to see what I could get on regional television, and the answer was the line across the bottom of the screen just doesn't do it.
No, it sure doesn't. Ian in Geelong, good morning. You're through to David.
Good morning, David and John. Thank you very much for your valuable segment.
How can we help you, Ian?
Is it possible to find out when a federal court when a judgment may eventually be released, and why it's being delayed a number of times?
The answer in practical terms is no. You can find out. The theory works like this: the judge hears the material, perhaps inviting additional submissions, perhaps not. And when the judge has all of the material, the judge then considers everything, and having considered everything, writes the judgment and then announces when it will be presented. Now, I actually have waited 19 months for a judgment, not in the federal court and not in Victoria. So sometimes they're fast. We actually got to the point where we thought we really should take out some life insurance on the judge, just in case. So, and that has happened in cases.
Oh, really?
Yeah, well, if you've got a 6 or 8 month trial, and we didn't, ours was a couple of weeks. But there are cases where they have taken out life insurance on the judge to cover the costs that both parties have expended.
In case they have to start all over again.
The judge will announce when the judge is ready to hand down a decision.
Okay.
Is it satisfactory? Not particularly. If you think it is unreasonably long, you can write to the judge in charge of the registry and you might express a gentle concern that it seems to be taking a very long period of time for judgment to be handed down, and I'm quite sure that the judge in charge of the registry will refer the matter to the judge hearing the case without identifying you.
How long is it now, Ian?
Two-part answer. The case that's before the court at the moment is just over 12 months, but the matter itself has been over 9 years.
Yeah, I understand that.
So it's a year.
So it's a year since the hearing finished and the judge was asked to go away and make a decision.
Yes.
I think you've got reasonable grounds to start asking about the reasons for that delay.
But it's a letter to the registry and you're just expressing your concern about the delay.
Okay.
All right.
Righto. Thank you.
Thanks, sir.
And look, I'll pop you back, and if there's anything that we need to know about it through the producers, do let me know. Sue in Ascot Vale. Hello, Sue.
Hello. Thank you for taking my call. My question is, how do I amend a family trust schedule for a
discretionary trust?
Discretionary trust.
Well, what kind of amendment do you want to make, Sue?
It's missing the settled sum. 3 years ago, the lawyer who set it up for the trust has set up the trust, but he has shut his business. But the trust only started producing income in the last financial year.
Yes.
And I've only found this out from my accountant.
So there's no reference to the settled sum?
Nothing. Usually people have a settled sum. I didn't know.
Well, the settled sum is when you create a discretionary trust, a person who we call a settlor gives some property, normally money, to the person who's the trustee. And that forms the nucleus of the trust. And it is otherwise funded by way of loans. I would be looking at a couple of things. You may have a claim against the lawyer who set the trust up for the cost of whatever the rectification is. And the process for amending the trust will be contained within the trust deed, but it won't cover this provision, and it might require an application to the Supreme Court for a declaration that has the effect of amending the deed. Right?
Okay, so I have to amend the deed before I can amend the... I remember it was something like a $20...
Yes, the question will be, though, was the settled sum ever actually paid? And if the settled sum was never paid, you've got more problems. But a lot will depend upon the precise wording, because sometimes the trust property is the promise to give you the $20 rather than the $20. So
that's allowed?
Yes, because it's the promise. The promise is the trust property.
Okay.
All right.
All
it's
right.
not perfect.
No. Although you're better off handing over the $20.
So, Sue, I would be getting someone to look at the deed. Do you know, if you know the firm that's taken over the one that was there, have a talk to them. It's probably, and it would be covered by the lawyer's insurance.
If it's big
so
enough.
So if the lawyer's gone out of business, if the lawyer's gone out of business, then the lawyer's insurer, the LPLC, will be ultimately responsible for the cost of fixing the mistake.
Which shouldn't be great anyway, would it?
If you've got to go to the Supreme Court, John, you could be at $4,000 or $5,000 before you blink.
Just to go in and say, hey, can you fix this up, please? Vivian in Anglesey. Hi, Vivian.
Hi, David and John. I got a question. We built a new home about a year ago, and the last public holiday, so the Labor Day, our internal switchboard, electrical switchboard, blew up. So we called an emergency electrician, being a public holiday, and he said to me that there was some dodgy electrical work that was done. So I asked him to write that on his invoice. He did all that. We paid it. Then I requested from the electrician who did the electrical work on our new home to request to reimburse the invoice, and could we have an independent inspector, because now we're concerned about our safety, at no cost to us. So he's come back to me saying he's agreed as an act of goodwill that he'll pay half of the invoice and that there is no need for him to pay for independent inspector. So I'm wondering, David, whether you have any thoughts about what I can do now, because I'd really like him to reimburse us for the full invoice.
Vivian, my starting question is, why not go to the electrician who did the remedial work and say to that person, is it all now okay or should I keep looking?
Okay, I did go back to him, and he said, you can be assured that it's safe now. But, we've had that situation. Yeah, he said it should be safe. I asked him if we were to get an inspector, would they do anything more than what he did? And he said the only other thing they could do is go to your PowerPoint outlets and have a look. But he said if there is any problem, the safety switch will go off, so you'll be fine.
So you'll be safe anyway.
Yeah, right? That's what he said. Okay, yeah.
You could, if you like, you could go to VCAT and have a go at the at the electrician who did your work.
Right.
But I'm just how much are we talking about?
We're not talking about. So the invoice was $264, and he's suggesting he's paying half.
He's prepared to give you half.
Yeah.
I suppose the question is, how much time and effort are you prepared to put into the $130?
Well, yeah. Well, it's more a matter of principle for me. But yes, I get where you're coming from.
Principles can be very expensive. Okay.
All right.
Good luck, Vivian. I don't know that I would do much more. I'd probably take the $130 and be satisfied with the electrician in whom you now have confidence.
All righty. I hope that helps you. Jill in Geelong. Hello, Jill.
Oh, good morning. Thank you for taking my call. Just got a quick one. I don't know if you can help or not. In 2002, the law was changed in regard to superannuation splitting for couples who had a property settlement.
Yes.
But people who were settled before 2002 still are bound to keep the same court orders they had then. They can't split their super.
There was a rising inflection. Do I detect a question in that, Jill?
Yes, there is a question because
the expectation
if you don't have any contact with the person who, like your ex-spouse,
yes,
how do you know when they do resign or retire from their work, because you have no way of knowing? And the court order, I only just found out recently, was against the person, not the superannuation fund. And I've been settled in my property for 20 years, so now I'm finding at 60 and not able to work, I can't even get what was a substantial amount of super.
And that's because your former partner, you don't know whether he works or doesn't work, is that right?
That's correct. And I believe because it cost me hundreds and hundreds of dollars to send off to find out from the super that he hasn't retired yet.
Yes.
But they're under no obligation to uphold any court orders for me, which I didn't know. I thought when he retired it would just be split and I would get my share. But apparently that's not the case.
I'm conscious about how much money you might need to spend.
Might need to spend.
Well, no. Look,
get the answers.
no. Well, the answer is that the arrangements that were in place when you settled are the arrangements that were in place.
Yes.
Now, if your former partner might be prepared to agree, you might go back and vary that order to make specific provisions in relation to super. But I can imagine he will refuse.
Yes.
And it's an order that binds him personally. It doesn't bind the super fund.
That's what I'm saying. So eventually I may have to take him back to court even though I thought it was settled 20 years ago.
It was settled 20 years ago. You might need to go back to court to enforce the order because the law, when you settled your claim, doesn't provide as it now provides.
Although the threat of going back to court, if it's as straightforward as Jill is saying, then the prospect of having to pay everybody's costs for a otherwise unnecessary court case might be enough to bring people to heel.
Except it's really Jill. He stands up and says, look, Your Honour, the order's put in place. I'm happy to abide by the terms of the order. I think it's a waste of time, effort and money to come here. I want Jill to pay. Mm-hmm. I think there's some argument in that.
Either way, Jill's going to need to get some specific advice about the exact wording of the order that she's seeking.
I already went and got advice to find out that he had not retired. I paid a lot of money to get that investigated, and I didn't want to go back to the lawyer again and say, but
No,
hey,
I
now we
wouldn't
know
either.
he's not retired. What do I do?
I would simply be sitting and waiting. I don't know. I couldn't recommend that you spend thousands of dollars to reopen the matter for the purpose of making sure that there was an order binding the super fund rather than your ex.
But things have moved on. Those orders tend not to be against individuals now. They tend to be...
Well, the law
dealt
changed
with-
in 2004,
Yeah.
and it's now possible to split a person's superannuation entitlement.
at the time rather
Yes.
than having to wait. John in Geelong, good morning to you.
Good morning, John and David. Just a quick one. My daughter was started her first job in the fast food industry. She was loving the job, but then was the subject of bullying by the owner's mother, who was also an employee there.
Yes.
The daughter, she made 2 complaints to the owner. Wanted to take it on herself, and didn't want her parents to get involved. So we hung back and let her do a thing, but nothing happened. So my wife and I then approached the owner and with the same complaints and informed her of her rights and obligations, but still nothing was done until one final incident which occurred. So we went down again and basically were told, my daughter was sent in a text message, basically, we'll terminate your employment is terminated.
Yes.
And can you please bring back your uniform and we'll give you back your deposit.
Yes.
And that was it. Nothing else happened. The behaviour didn't change according to other staff members, and this is, in our discussions with the owner, she said, look, this isn't the first time I've heard this, but it's my mother, it's her ethnic background, and that's just how she is. She's abrupt, and I can't change that. What do you think our best course of action would be?
Well, bullying can constitute a criminal offence. So if there was bullying, you could do something about it. You could also possibly bring an action for wrongful dismissal.
Fair work.
Because there does a fair work claim, because there doesn't seem to be a basis for the dismissal.
And the fact that someone is elderly or from a different cultural background is no excuse in the workplace whatsoever, David, is it?
No, the rules apply to all of us, not
Yeah.
just some of us.
So, John, if your daughter wants to, she can go off to Fair Work and ask for a wrongful dismissal application to be processed.
We did bring up Bronte's law and, how the law had changed and what was happening was wrong, but it fell on deaf ears, unfortunately.
Well, I think if you were to say, well, we've sought some advice and we're going to have to go to Fair Work if we don't get a quick resolution of this, at least they might call you bluff, but you might find they come.
Make the call
to the
today,
table.
John. Quick resolutions for work. Fair work claims need to be brought very quickly.
All right.
Okay, thanks very much.
Thanks, John.
And I'm sorry that's all there's time for today, and I know there's lots of people waiting, and there are people sending in text messages in answers to questions, particularly about safe electricians. You need to check out whether the electrician's licensed and as claimed, or whether they're doing substandard work for other people as well. So a complaint to the licensing body is recommended by several people. And Bill the Builder says if the house was built within the last 12 months, then the builder's defect claim should even cover the electrician.
The emergency electrician,
if it's within the 12 months of the completion of the certificate of occupancy, I think is the
There'll
trigger
also be
date
a
there.
certificate of electrical safety, which will disclose the number of the electrician. And if you want to express a concern about it, you can talk to the regulator, which I think is the Building Commission, and talk to them and say, got a complaint, here's my complaint, and they will investigate.
And John from Preston says he saw a backhoe pull down. I'm sorry, it's Bill in Preston saying to me, John, I was in Preston and I saw a backhoe pull down a power line in Victoria Road, Northcote. I witnessed it. So if indeed that is the same incident that our first caller was calling about.
Warburton.
In Warburton. Okay, well then
close though.
Warburton and Northcote are a very long way away from each other. But there you are. There's lots of other issues with power lines being pulled down by inappropriate loads on trucks too.
Thank you, John.
Thank you, David. David Whiting, our talkback lawyer, helping you with free legal advice. And David will be back at the same time after the 10 o'clock news next Tuesday.